So today's topic is pets and non-pets, because the truth of the matter is when you're a landlord and you are leasing rental property, people have animals around them. And even if they don't have them at the beginning of the lease, you may find that a few months in, all of a sudden, there's a new animal in the home and you've got to deal with it. It's important that you have a specific strategy for dealing with animals and that you're the most upfront with that strategy with your tenants from the beginning. In fact, during the application process, you should go through your policy with your tenant so that it is clear and concise, easy for you to prove that your policy is consistent throughout the lease term. So today we're going to talk about the things to do before a lease, during the lease, and as a lease comes to an end, as it pertains to animals that are owned by your tenants. Let's get started. So naturally, you want to begin the conversation during the application process. And it's important that when you are finding out about the animals associated with your tenant, that you don't limit the question to just pets. And while that may sound silly, you really should ask about all the animals involved with your tenants. How many animals do they own and how many do they plan to bring on to the rental property? You may have certain animals that the tenant simply does not regard as a pet, but they're animals that they own. And because of that, you don't want somebody hung up on a technicality. So in order to cover all of your bases, make sure to ask about all animals. You also want to get a description of the animals that the tenant plans to bring, that they currently own and that they anticipate having at the time of the rental. You'll want to get things like photographs. You'll want to get a written description of the size and the breed and the color and the type of the animal that they plan to have, that they currently own. Naturally, if they have a puppy at the beginning of the lease, they're not going to likely be a puppy 2 or 3 years later. But if they have one adult dog and by the end of the lease they have one adult dog and 3 puppies, well, you know something changed. And so you'll want to be able to have documentation about that original animal that was mentioned in the application process. You'll also want to be upfront with the limits of the kinds of animals that you will allow on the property. There are limits due to size and weight, the number of animals that you will allow. Make sure that you're explicit and you describe the prohibited animals. Certainly you don't want any exotic animals, and certainly you don't want any animals that would violate city or county ordinances or your homeowners association covenants. Additionally, you'll have to consider what your own insurance policy will and will not allow in terms of acceptable breeds of animals or numbers of animals, so that your insurance policy remains valid. Next, be prepared to discuss service animals and emotional support animals. These are not pets. And because they're non-pets, you cannot charge a pet deposit for them, nor can you use these, generally speaking, as a basis to prohibit your tenant from staying on your residential property. Tenants have certain protections under federal and state laws in order to own and use these kinds of animals. And so it's important for you, number one, to know the basis of the use of either a service animal or an emotional support animal, but also the justification for these. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing. So here's a simple test that you can go through when you are discussing these, either at the application process or during the tenancy when the need for such an animal arises. First, if the disability is open and obvious, you'll have to ask, does the animal itself serve a necessary function? If it does, then you have to allow it. For example, if a tenant suddenly goes blind and they suddenly are in need of a seeing eye dog, that's textbook. they have an open and obvious disability, and an animal that serves a very specific function. If, however, the disability is not open and obvious, you can ask for proof of medical need, and then you can also ask for proof that the animal in question satisfies that medical need. Beyond that, you don't have much. So it can't simply be a matter of self-diagnosis where a person says, well, I need this emotional support armadillo because I have anxiety and it helps to relieve my anxiety. If there's no legitimate medical basis for this, and there's no proof that the animal itself serves this legitimate purpose, then it doesn't appear that this particular animal qualifies as an emotional support animal. However, generally speaking, if a tenant can supply some kind of documentation from a qualified medical professional and some kind of certification that the animal serves this function, technically the tenant is allowed to have this animal, and a reasonable accommodation should be made for the tenant to have the animal in your rental unit. Again, this is not a pet, and so this animal cannot be, or the tenant cannot be assessed a deposit fee for the animal. Now, certainly this is a gray area in the law, and the facts of your specific case may need to be reviewed by an attorney. If in your case, you are still unclear, even after these simple tests, you're still unclear whether or not you absolutely must allow a tenant to reside on your property with a particular animal, or if you're unsure about the disability, or you're unsure about the medical basis and its legitimacy, you may want to seek out a landlord-tenant attorney in your area. If you're interested in giving us a call, our information is here on the bottom of the screen. Don't hesitate to reach out to us. We'll be happy to help you. Now, it's also important to note that the fact that the animal itself is a service animal or an emotional support animal does not give the tenant carte blanche when it comes to damage on the property caused by this animal. If the animal causes damage, that alone may be a basis for you to send a notice of default and to assess damages against the tenant for which the tenant is liable. Again, the fact that they are a service animal or an emotional support animal doesn't necessarily prohibit you from charging the tenant for damages caused by that animal. Finally, it's important for you to be vigilant after the lease is entered into when the tenant introduces an unauthorized animal. One way to handle this is to conduct inspections. We always recommend that you conduct at least 2 inspections per rental year. And our suggestion is that you do it at the 3rd month and on the 9th month. It gives you an opportunity, number one, to have a snapshot in your application process of the animals that were there at the beginning, what has changed after 3 months, if anything, and what has changed 6 months after that, if anything. And it gives you an idea of whether or not you're going to want to renew this particular tenant. If they started off with 1 pet and then grew to 3 and now they have 6, you may be convinced that extending this lease is not a good idea. However, if the tenant has remained consistent with the same number of animals throughout at the 3-month and the 9-month review period, then you've got a pretty good indication that another year you'll see pretty much the same. Now, as you proceed, even if a tenant has paid a pet deposit for 1 animal, that does not mean that the deposit extends to new ones. Again, they may have come in with a 10-pound dog at the beginning of the lease, but now they've got a dog and a cat and a bird and a fish. You have to decide whether or not this is still in compliance with the lease that was entered into. If you signed a lease and it included a pet addendum for a single animal and now the tenant is in violation, it's important that you send a notice of default in writing, allowing the tenant an opportunity to pay the additional deposit or to remove the additional unauthorized animal or animals. This is important, particularly if you plan to evict for continuous and numerous violations of the pet agreement in your lease. In order to set up a good case for eviction against a tenant in this situation, you're going to want to make sure that you can prove that you've given a reasonable opportunity for your tenant to cure their defect. You're also going to want to make sure that you have collected adequate photographic evidence of any of the pets that violate the pet addendum or the pet section of your lease. And you want to make sure that you respond with a demand for possession. In other words, that you file your eviction quickly. If you wait a number of months, the court's not going to regard this as a legitimate violation. If they are in violation and you give them 7 days, for example, to cure that default and they haven't done it, then move on to the next step, which is a notice to vacate, and then file your eviction. If you wait weeks and months, and this is the only violation that you can cite, the court may say, look, you sat on your hands on this. It doesn't, if it didn't bother you the first 2 or 3 months, I don't know that it's sufficient for me to evict these people at this time. But if you are prompt and you are diligent, then you are likelier to get the result that you seek. And if the tenant simply will not do what is necessary to be in compliance with the lease, then the court should honor your request for possession of the property for a tenant who is in violation.